Alex here with a high conflict child custody video on the 3 phases of conflict. And this is just something that I've observed over the years. And I hope that my understanding of high conflict child custody cases helps people to understand their own high conflict child custody case. The first thing that I want to mention before I even start is that these solutions are for people who are in high conflict child custody litigation. If you're not in litigation, then this isn't for you. What you should do is just stop talking to them. Block them on all your devices. Don't email them, don't call them, don't talk to them. You're done. Move on. If they won't let you because they're stalking you or something, sue them. Go for, I don't know, an anti-stalking order, whatever it takes to get this person to leave you alone. Use the law, because otherwise, I don't know what you could possibly be going through. I've heard of some people going through horrific tales, like people calling their job and saying crazy things about them, or destroying their car, vandalizing their car. All that stuff. I'm not talking about all that stuff. People who are in a high conflict child custody case, who are in court, they can't do that. They can't just stop talking to them. They can't just stop emailing them. They can't just block them on all their devices. And the reason why they can't do that is because the court will expect them to in some way communicate with their high conflict ex, because the court won't understand the mental health behind the problem. The court will just think, well, you're the problem parent because you won't talk to your ex. Next thing you know, you're losing your parental rights. So you have to coordinate and communicate with them in some way. For people who are wondering my advice as far as communication, watch the video Communication, because I'm not going to talk about that here when I've already dedicated an entirely separate video to that particular part of the problem. And that is a big part of the problem. I don't want to minimize it. It's a video that goes into so much detail as to how to deal with the communication problem. The other thing is how to deal with a failure to agree. This ends up being another huge problem, and I'm not going to talk about that in this video because, again, I have another video dedicated to that particular part of the problem, and that video is titled Failing to Agree. So definitely watch the videos Communication and Failing to Agree, because if you just watch this video without those two, I don't think this video is going to really cover the entire problem, and it might seem like it's a little bit light even. My understanding of the 3 phases of high conflict child custody litigation are as follows. The first phase is the opportunity to agree, and everyone really ends up going through this part of the process. I think all 50 states have tons of mechanisms in place to help you agree. In fact, it's almost to a fault. Many states and many judges obsess over this part. They can't get past it, and that's one of the reasons why those judges are incompetent at dealing with high conflict child custody, because they take this approach and they don't let go of it, and they think if you can't solve your problems through this approach, something's wrong with you. Which, okay, great, something's wrong with this relationship, but how does that help our kid? Okay, that just puts a label on our relationship as a problem relationship. We need solutions. Anyway, the agreement phase is the phase that you should participate in wholeheartedly. You should participate in the mandatory mediation. That's at least one mediation that's mandatory. And you should participate in good faith during settlement, and you should communicate with your ex and try to work things out until you realize it's pointless. And those of us who are in high conflict cases will move on past this phase. There are a lot of people who don't. There are a lot of people who they separate and they both want the case to end. They both are happy to get the case to end. They want a fair resolution, but neither one of the two thinks, oh, I love this. I hope this goes on for 10 years. No, there are people who think that, and that's those of us who are stuck with an ex in a high conflict child custody case. But for those of you who aren't, use all of those tools. The case management conference is an opportunity to settle. The settlement conference is pretty much dedicated to just that one thing. And I can't think of a state out there that doesn't have at least one mandatory mediation. That is just, those are just 3 or 4 of the things available. And then you've got the attorneys who should be able to work things out as well. Most attorneys do want to work a case out. The only exception I can think of is an attorney with a rich millionaire client that really might be a little bit more gung-ho about litigation. But most of the people out there, especially if you're paying $5,000 retainers, those retainers aren't meant to go to court. Those retainers are typically meant to work things out through the settlement process. Those retainers aren't even meant to go into discovery. That's how little money that is to an attorney. And anyone out there who's paying their attorney $5,000 retainers or less, that's typically the type of case you're going to go through, is an attorney who's really pushing hard for you to settle your case at mediation or at the settlement conference, because they just don't have the money to go even through discovery, much less trial. So phase 2 is get to trial as soon as you can. And I hesitated there because some people, sometimes they've already waived the right to a trial. And so for you, it might be called an evidentiary hearing on a post-judgment motion to modify. It's going to have a much more complicated sort of phrase behind it. But the point is, if you have gotten past the settlement phase and you have not been able to resolve your case, push for your trial as quickly as possible. A lot of attorneys don't like the sound of this, and I'm going to talk about that a little bit more. But one of the things that I want to stress before I even get into that is, don't go backwards. If you are dealing with a high conflict X, you're going to notice that they don't use settlement and mediation constructively. They use it as an extension of litigation. They may use it as another opportunity to attack your character, accuse you of things, blame things on you. They might think of the mediator or the settlement judge as a person who they need to get on their side. All of these approaches are wrong-headed. They're a waste of your time. Sometimes you even have to pay money to go through this stuff. Like, mediation isn't free in Nevada. You have to pay a couple $100s, I think. Some people, they waive it for when they're poor, but everyone else has to pay. That's it. Once you move on to phase 2, you're done. No more settling, no more mediation. They're just going to string you along. They're just going to play games with you. And if you are going to get any kind of agreement with this type of person, it's going to happen because you forced them to do it. And I talk about how this happens in the video delay tactics. I explain in the video delay tactics that the best way that you can get an agreement or a settlement out of your high conflict X is to put their back to the wall. And that is by either setting a deadline on a motion, so they have to file a response, or by getting a hearing or a trial of some sort. When they have those hard limits, those dates looming over their heads, you can sometimes, not always, sometimes get a settlement out of them. Not because they want to settle, but because they start to freak out. They're about to go to court. That day is approaching and they can't hold it off any longer. And sometimes that'll force them into settlement. The reason that I think it's important is because oftentimes the person that is going up against a high conflict X is in a very unfavorable situation, and time hurts them. It helps the X, it hurts them. So if they're dealing with an X who has a custodial designation that's favorable, and they're sort of trying to get to that fair resolution, the last thing you want to do is drag things out and wait and go round and round. And I said I was going to talk about this. A lot of attorneys I don't think would agree with me here, because I think a lot of attorneys do take the approach of, let's just wait and see, postpone this thing for a year or two. And I think when they do that, they do get a settlement eventually. And I think that that makes those attorneys and maybe even the court feel like, hey, this works. This approach works. Let's not set a trial. Let's deliberately push this out 6 months, 9 months, a year. Because in the last 10 cases that I did this, it worked. They settled. Well, the problem is that just because they settled doesn't mean it's in the best interest of the child. Oftentimes what happens is the targeted parent or the victim parent just gives up. And just because they went away doesn't mean that the child isn't being abused into oblivion. I talk about this in detail in the video. End of filings is not end of abuse. That's the title. In the video, end of filings is not end of abuse, I explain how this idea that just because everyone stopped filing papers, everything must be now really fine. Everything's fine. Everything's okay. Everyone's great and the child is happy. That idea is so wrong. It's not true at all. And just, it might be true in like 1 out of 4 cases, but what happened is the person who's trying to protect the child just quit. They just said, I'm done. I'm walking away. It's not working. I'm not able to get a hearing. I'm not going to court. My attorney's just giving me the runaround. I'm being strung along. Fine. I give up. Just give me some visitation. Meanwhile, the child's being abused, the child's getting bad grades, but the other parent figures the system doesn't care, and so they walk away. So that's why I think a lot of attorneys and judges think that this approach works when it really doesn't. And they just don't understand it. What they do understand is less work. Filings aren't being put into the system. We don't have to go to court and argue at hearings, so So it's less work. So it must have worked. It must be working for those parents. They must have worked things out. No, they didn't work it out. One of them just gave up, and the other one is just doing whatever they want to do. And that's just the end of that situation. It's going to be a sad conclusion for that child. The third, okay, I think I've covered the first, which is use all of the tools at your disposal to settle and agree. The second one is to get to trial as quickly as you possibly can. The third one is the end. It's the sad realization that you're going to have to abide by court orders as strictly as you possibly can, and you're going to have to do that potentially for years because you have gotten your final decision, and hopefully it was favorable to you, and the conflict has continued. And so what you have to do is tighten and restrict as many avenues of the custodial relationship as you possibly can. Tightly restrict and control communication. For example, put it through Family Wizard and have very strict boundaries in place. Do not bend the rules ever, because if you do, when you're at this point, anything that you do in good faith will be weaponized and used against you. And I talk about this problem in the video, Exploiting Good Faith. When it comes to swapping time, try to never do it if you possibly can, because again, it'll just be used against you. In my particular case, I tried to swap time and my ex said that I dumped the child on her and didn't want him. Another time, my ex said that I went to a vacation without setting up any kind of babysitter for him. When in reality, what I told her was, if you want to watch him, you can. If not, I'll put him with a sitter. What they'll do is take any act of kindness and use it against you. Another thing that they'll often do is they will let's say you bend the rules once and go and allow them to do something against the court order. They'll start to violate the court order on purpose. And then they'll say, hey, you said I could do this last time, so I just thought it was okay to do it this time. And they use these defenses in court. And because the explanation is plausible, they often get away with it. So the third stage is the strictest stage. Object to mediation, object to settlement, use every court rule and statute that you possibly can to avoid going to those things, because it's a waste of your time and they're just going to play games with you. Keep the court orders as strict as you possibly can, and don't flex or bend in any way, shape, or form, because it's just going to be used against you. That's what's going to happen. Now, if you have any questions about what I'm talking about, if you need more details, you can feel free to post them down in the comments below. I think that, and this is me just kind of going off on a tangent, I think it would help the legislature and the judiciary a lot to take this multi-pronged approach to dealing with these custody situations, because I think oftentimes what happens is they try something, but they try to sort of make it a one-size-fits-all solution. They try, okay, let's end the conflict by forcing settlement, and all the parents can go through this process, and if they don't like it, too bad. Okay, that's not working. Let's put some strict rules in place for shared custody. Everyone gets joint custody just by default. That's what they all get, unless they, prove. It's not even just prove. It's like you have to go to hell and back and climb 3 mountaintops to prove that it doesn't work in your case. It's like the court takes these extreme approaches, and they don't really know how to take these different ideas and sort of harmonize them. And I think that it would be nice if they would do something like this as well, if they could have sort of 3 different phases for these cases. First, we'll try this, and then if this doesn't work, we're done with it. No more settling. Now it's trial, trial, trial. Move as fast as you can, set a trial date, get your evidence together, and go. Okay, that didn't work. We're in phase 3 now. Be as strict as you possibly can. Somebody violates an order, jail them, fine them. There's just different types of people that go through this process, and different types of people are motivated in different ways. Most of the people are going to respond well to the settlement idea. Most of the people are going to go through that door, and they're going to walk out and be done. And the remainder of the people, they want to be heard. So stop trying to send them back to settlement. Let them get their day in court. They need that for whatever reason. Maybe that child really does need some kind of protection. Listen to them. Open your ears and pay attention. And then you're going to have the smallest percentage of people, which are the ones that just don't stop. And when you get to that point, it's time to be strict. It's time to pay a lot of attention and find out which parent is the high conflict parent and do something about it. That's what phase 3 is about. Phase 3 is about control and force, which is very different from phase 1. And I think that's one of the reasons why judges struggle with it, because they can't get their head around two or three different approaches to a problem. They just want one size fits all approach for everyone. And when it doesn't work, they just get frustrated, throw their hands up and quit. So anyway, I don't know, a little bit of a tangent there, but that's just my perspective as to what I think the judiciary and the legislative approach should be to this problem. And maybe someday it will be, but for now, you kind of have to work around the court's dysfunction. If anyone has any questions, as I mentioned earlier, post them down in the comments below, and I will see you guys next time.